Judiciary, Civil, and Criminal Jurisprudence come to order. Since we do not yet have a quorum present, we are going to operate as a subcommittee to start off. So I'm going to kick it over to Senator Schroer to chair the committee, and we're going to start off with Senate Bill 1468.
Senator, please take the stand and begin on Senate Bill 1468 when ready.
Thank you, Mr. Chairman, members of the committee. For the record, Tony Luetkemeyer, representing the 34th Senatorial District, here today to present on Senate Bill 1468. The First Amendment of the United States Constitution protects the establishment and free exercise of religion. Recognizing religious property should be protected against eminent domain by the First Amendment, courts rarely allow governments to condemn churches or other houses of worship, as it would constitute a substantial burden on the faith community's free exercise of religion. Senate Bill 1468 protects religious organizations by prohibiting cities, and we will expand it to counties and other entities, from condemning land owned by a church, synagogue, or other religious organization through the use of eminent domain. This bill would ensure that communities of faith are able to exercise their First Amendment rights by ensuring that churches are not condemned by governmental actors. And with that, Mr. Chairman, I'd be happy to answer any questions.
Senator Coleman.
Is there a story about why this is being brought forward, or what the history of this bill is?
There may be a baseball stadium that's being proposed in the city of Kansas City that has within its footprint a church, and there may be some discussions about whether eminent domain would be used to take that church down in the event there was not an agreement by the church to sell the property.
Thank you.
Senator, on some of these condemnations, we've heard this, the Greenway and all of these other issues since we've both been up here. Another issue has been brought to our attention in St. Charles County, St. Louis County, and St. Louis City of some condemnations and eminent domain being utilized on certain pieces of property that may have a bank note on them still. Do you believe, and I don't know if you're open to it, we can have a discussion offline, but do you believe that in condemnation suits or utilizing eminent domain, that the property should be made whole by, the property owner should be covered in all of the back owed bank note on that as well?
Well, certainly. I mean, I think that when you exercise eminent domain, you have to pay the reasonable value of the property. And I would think if you have an outstanding loan on it, any reasonable seller of that property would want the loan to be paid off before they sold it, because then you'd be selling a piece of property and you would still then owe money on the property. That doesn't seem like it would be a reasonable value. So I'm certainly happy to have some offline conversations about that. To Senator Coleman's point from earlier, I mean, this bill really is intended to address a specific, potentially eminent issue in my own community, and so that's the reason for the legislation. And so certainly,
and is that being utilized? Is eminent domain being utilized to make way for the stadium right now?
So there is a vote that's occurring in April that would allow there to be a tax levied if it's approved by local voters. I think that some of the conversations about eminent domain will not happen until after that vote occurs. So it's still early, but I want to make sure we get a jump start on it. I mean, last week was the last week to file bills, and I actually filed this the day before the last day for bill filing.
Very good. Any further questions? Seeing none. First in support. Well, actually, show of hands. Who's in support? And who is testifying in opposition? All right, those in support, come on up and make sure you fill out a witness form, leave it on the desk there, and proceed when ready.
Hi, my name is Timothy Faber, and I must admit I was not aware of this bill until just now, so I'm glad I was here. But as a minister for 4 decades, it's something that I would certainly support.
Any questions? Seeing none. Thank you for your testimony. Remember that witness form. And next in support, please come forward. Seeing none. Anyone in opposition, please come forward. Seeing none. And any... Oh, you're blocked back there. Come forward and make sure you have a witness form. You can proceed with your testimony when you are ready.
My name's John Stambaugh. I am just a citizen of Cole County, and as this gentleman was, I wasn't aware of this this bill, but I'd have to say that I'd have to be in opposition to this just because I don't understand why a church would have more precedence over any other person's piece of property, you know, like the power lines that are going through North Missouri and the Tiger Express and what have you, where through condemnation it's basically taken. So, and I pushed hard against this, and I can't remember the year. It's probably around 2000 era. All I know is that my representative at the time was Bill Gratz, so you can research back that. But the use of condemnation was generally for the betterment of the good of the people, a government type project. Well, back in that era, up in Boonville, Missouri, there was a gentleman that had a scrapyard business, and they used eminent domain to condemn his scrapyard business so that the casino boat could go in. And then they justified the use of eminent domain because it would generate more tax revenue. And I told my legislator at that time, I says, you are setting one heck of a precedent. That is not the intent of eminent domain and should have never been, but they passed that through. So now we have just, you know, perpetual situations where eminent domain is used for the betterment of a business, not necessarily the betterment of the people as a whole. Like I say, I understand, you know, him wanting to protect that entity, but why should it be protected more than anybody else's property? You know, I think there was legislation, and I'm sure he probably knows it better than me, that if eminent domain is used, you had to pay 150% of the assessed value or appraised value of that property. So it was a little bit of a, you know, additional compensation if eminent domain was used. But, you know, not that I have any issues with them, you know, being a church or whatever it is. That should have never been changed, where basically I can condemn your business because another business can come in and generate more revenue. So I don't think that it should get special dispensation just because of it's a church.
Thank you for your testimony. Any questions? Seeing none, make sure you leave the witness form. Anyone else in opposition? Seeing none, anyone for informational purposes? Seeing none, Senator, any last words? This concludes the hearing on Senate Bill 1468. We will now move to whatever bill the chairman says when he returns.
Okay, next up is going to be Senate Bill 1372. Senator Eigel, whenever you're ready. Senator, give me just 1 second here. It looks like we have a quorum now. So, Madam Secretary, if you could please call the roll.
Senator Luetkemeyer,
Here.
Schroer,
Here.
Coleman, May, Roberts, Thompson Rader, Trent.
We do have a quorum present. Now make a motion that we go into executive session. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. You guys have it. We are in executive session. And I make a motion that we bring before the committee for consideration Senate Bill 869. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. You guys have it. We are in executive session. Senate Bill 869 is Senator Moon's bill from last time. It's the one that creates lifetime protection orders for individuals who are charged with dangerous, or actually convicted of dangerous felonies. It restrains the defendant from contacting the victim if they've been convicted of a dangerous felony. You don't have to keep coming back to court and having victims re-victimized by having to appear in front of the defendant multiple times. Is there any discussion on the bill? Senator Coleman.
Just briefly, haven't we passed this multiple times in the last year, and even back? I thought there's been Representative Roberts had a bill similar to this, Lane Roberts, that was signed into law last year.
So we looked and we could not find anything. I know, I think Senator Thompson Rader may have also had some similar legislation, but I don't think it put in place lifetime orders of protection.
Okay, thank you.
Yep. Any further discussion? Seeing none, I now make a motion that we do pass Senate Bill 869. Do I have a second? It's been moved and seconded. Madam Secretary, please call the roll.
Senator Luetkemeyer.
Aye.
Schroer. Coleman. May. Roberts. Thompson Rader. Trent.
By your vote of 5-0, you have voted do pass Senate Bill 869. I now make a motion that we bring up before the committee Senate Bill 1007. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. The bill is before the committee. We do have a Senate committee substitute. This is 1007. This is Senator Crawford's bill from last time. It establishes the Uniform Fiduciary Income and Principal Act. The only changes in the Senate committee substitute, they changed the section number. There's some cross-references that needed to be clarified in the bill, so it's just a technical change. Otherwise, it's identical to the bill that we heard in committee last time. And is there any discussion before I make a motion to adopt the committee substitute? Seeing none, I would now make a motion that we adopt Senate committee substitute for Senate Bill 1007. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. You've adopted Senate committee substitute for Senate Bill 1007. I now make a motion that we do pass Senate committee substitute for Senate Bill 1007. Do I have a second? It's been moved and seconded. Any further discussion? Seeing none, Madam Secretary, please call the roll.
Senator Luetkemeyer.
Aye.
Schroer. Coleman. May. Roberts. Thompson Rader. Trent.
By your vote of 5-0, you have voted do pass Senate committee substitute for Senate Bill 1007. I would now make a motion to bring before the committee Senate Bill 1200. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. The bill is before the committee. This is Senator Trent's bill. We do have a Senate committee substitute. Because it is Senator Trent's bill, I'm going to kick it over to him for the explanation of the substitute.
Thank you, Mr. Chairman. So the substitute, I think that there's a copy at everyone's desk here, modifies provisions relating to the notification to the Department of Revenue. It also modifies provisions relating to the defendant requesting the prosecuting attorney to divert his or her case to the DWI program, and adds a copy of that request to information sent to the Department of Revenue. It adds a new provision of ineligibility, which is if someone refuses to participate in a breathalyzer test, and it adds any costs for noncompliance to have to be paid by the defendant and are not subject to discounted rates.
Is there any discussion before we make the motion to adopt the Senate committee substitute? Seeing none, I would now make a motion that we adopt Senate committee substitute for Senate Bill 1200. Do you have a second? Yep. It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. You guys have it. You've adopted Senate committee substitute for Senate Bill 1200. I would now make a motion that we do pass Senate committee substitute for Senate Bill 1200. Do you have a second? It's been moved and seconded. Any further discussion? Seeing none, Madam Secretary, please call the roll.
Senator Luetkemeyer.
Aye.
Schroer. Coleman. May. Roberts. Thompson Rader. Trent.
By your vote of 4-1, you have voted do pass Senate committee substitute for Senate Bill 1200. I now make a motion that we bring before the committee Senate Bill 1220. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. The bill is before the committee. This is also Senator Trent's bill. We also have a Senate committee substitute, so I'm going to send it over to Senator Trent to explain the bill and the sub.
Thank you, Mr. Chairman. So the only difference between the sub and the bill that we discussed in committee, and actually I think we brought this up during the committee hearing as well, is that instead of having the circuit court en banc, we would have the governing body of the city or or the county or city not within a county to approve the alternative juror compensation package. And the reason for that is that we wanted the entity that's going to be bearing the cost to make the decisions, that they would be most appraised of what was the budget is capable of sustaining. So I'd be happy to answer any questions.
Any discussion? Seeing none, I would now make a motion that we adopt Senate Committee Substitute for Senate Bill 1220. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those the contrary, no. You guys have it. You adopt the Senate Committee Substitute. I would now make a motion that we do pass Senate Committee Substitute for Senate Bill 1220. Do I have a second? It's been moved and seconded. Any further discussion? Seeing none, Madam Secretary, please call the roll.
Senator Luetkemeyer.
Aye.
Schroer. Coleman. May. Roberts. Thompson Rader. Trent. Senator Coleman.
By your vote of 5-0, you have voted do pass Senate Committee Substitute for Senate Bill 1220. Now make a motion that we bring before the committee for consideration Senate Bill 1370. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those the contrary, no. The aye has it. Bills before the committee. This is Senator Black's bill. It establishes treatment courts for mental health treatment. We have a lot of different treatment courts currently under the law, including drug treatment courts and veterans treatment courts. This would add mental health treatment courts. This was a priority for the Judicial Conference this year, and I believe also the Missouri Bar. Is there any discussion on the bill? 1370. Mental health treatment courts. Any discussion on the bill? Seeing none, I would make a motion that we do pass Senate Bill 1370. Do I have a second? It's been moved and seconded. Madam Secretary, please call the roll.
Senator Luetkemeyer.
Aye.
Schroer. Coleman. Senator May. Roberts. Thompson Rader. Trent. Senator Coleman.
By your vote of 5-0, you have voted do pass Senate Bill 1370. I would now make a motion that we exit executive session. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. We're out of executive session. We are back up on the hearing for Senator Eigel, Senate Bill 1372, whenever you're ready.
Thank you, Mr. Chairman. That was breathtaking. Thank you, Mr. Chairman, members of the committee. I'm State Senator Bill Eigel, the 23rd State Senatorial District, and it's my pleasure to present to you Senate Bill 1372, creates and modifies provisions relating to illegal immigrants. I think that most members of the committee are very familiar with the invasion that is going on right now as we speak down at our southern border, and really the failures of the federal government led by President Joe Biden to deal with that, to close the border, and to enforce our immigration policy so that we have a sane process for folks that want to come into our country legally. As a result, we've seen an influx in illegal immigration into the state of Missouri, like almost every other state in the union, and that has come at a significant cost to the state in terms of both fiscally, which the cost right now of illegal immigration in the state of Missouri is estimated to be north of $2 billion annually to our communities, and also in terms of crime statistics. Many of the conduits that are being used for illegal immigration are also being used for human trafficking, for the fentanyl trade that is coming through our urban zones and spreading out to some of our rurals and suburban areas. So Senate Bill 1372 attempts to be proactive in how we deal with illegal immigration in the state of Missouri. And specifically, it creates a state offense of improper entry. And a person would commit the offense of improper entry by an alien if the person enters this state at a time when they are unlawfully present in this country under federal law. Now, historically, the federal government has been the leader on immigration policy, and I think that policy for the past 200 years has been a good one. However, we now see at this time that the federal government is abdicating its role of protecting the sovereignty of the state of Missouri and the other states in this union, which is what's making legislation like this, an action by the state, necessary today. In addition to that, we're adding, Senate Bill 1372 also includes a prohibition on the receipts from the General Assembly that goes towards the public benefit of any illegal alien present in the United States and prohibits them from receiving taxpayer support or taxpayer money. Finally, it also includes a prohibition against enrollment in our post-secondary institutions. The Supreme Court has already ruled that states can enact a prohibition of enrollment for public universities for illegal immigrants, and 3 states have actually done that. Georgia, South Carolina, and Alabama have all introduced and passed prohibitions against enrollment for illegal immigrants in post-secondary institutions. That would be included under this bill as well. Members of the committee, this is an effort for the state of Missouri to be proactive about the sovereignty of its borders and to begin addressing what has been a crisis that has led to the tragedy of Lake and Riley. If we can prevent even one more of those through legislation, I think that's a worthy cause. Mr. Chairman, I'd be happy to answer any questions.
Any questions for Senator Eigel? Senator Schroeder.
Thank you, Senator. This, I think, is a very good bill. I'm on page 6, the last section, under section 577.690. It says, any law enforcement officer whose duty it is to enforce criminal laws of the state may, upon probable cause that a person has violated subsection 1, arrest or detain such person in a manner consistent with Chapter 554. Would you be open to, and you can provide your rationale for having a may on line 33, would you be open to changing that may to a shall?
Yes, I would absolutely be open to changing that may to a shall.
Well, thank you.
Any further questions for Senator Eigel? Seeing none. First witness in support of Senate Bill 1372. Witnesses in support. And by the way, we are going to, for witnesses, to the extent there are multiple witnesses, first witness is going to be given 5 minutes. So whoever is the lead witness, which if you're the lead witness, that's perfect. And then subsequent witnesses will be given 2 minutes apiece. So that way we are able to get through the hearing in an orderly fashion. So,
Mr. Chairman, I
Yes.
apologize. I'm needed in another committee.
Yep. No worries.
So I will excuse myself
Sounds good.
by your leave. Thank you.
So Lisa, you're the star witness.
Wow, great. The star. I've been the star talking about all the illegals every time these other bills come up, so I guess it's fitting. Lisa Panett, Armor Vine, obviously. And this is just a common sense bill. We're seeing more of these illegals flood in to our state. The child that was killed in St. Charles County was tragic. We actually have a candidate that's running for lieutenant governor that his son was greatly impacted by an illegal out of Texas in a car crash and nearly killed by an illegal. So I think we're going to see this, unfortunately, hitting home for us, and we need common sense solutions. So I'm appreciative of the legislation. I'm appreciative that you found the may and want to change it to a shall. I think it should be a shall. And that's it. I conclude my testimony.
Any questions for Ms. Panett? Seeing none, thank you
Thank
for your
you.
testimony. First witness in opposition. Witnesses in opposition to Senate Bill 1372.
Well, good afternoon, Mr. Chair and members of the committee. My name is Dr. Guillermo Villatrueva, representing the Missouri Catholic Conference, and we would like to go on the record in opposition of Senate Bill 1372. And we oppose both of the issues that this bill sets forth, banning undocumented students from enrolling in a post-secondary educational institution and creating the offense of improper entry by an alien. Regarding the first part, banning undocumented students from enrolling in a post-secondary educational institution is not only inhumane but also unreasonable. Let's think for a moment about who would be impacted by this provision. Students who have already completed basic education in Missouri schools, who are active members of their communities, who are well integrated within society usually, and who in many cases only speak English and can only remember ever living in this state. And this bill would violate their God-given dignity and discard valuable people in whom the state has already invested a lot of resources through basic education and who could alleviate Missouri's labor shortage crisis. Regarding the second portion of the bill, the Catholic Church teaches that the more prosperous nations are obliged to the extent they are able to welcome the foreigner in search of security and the means of livelihood which he cannot find in his country of origin. The Church has always acknowledged both that the people have the right to migrate, to sustain the lives of their families, and that countries have the right to regulate their borders and to control immigration, as long as they do so with justice and mercy. However, laws that are overly punitive and disproportionate can never be just or merciful. Let's imagine a father and husband who has lived and worked in Missouri peacefully for the past 15 years, but is undocumented. Should his family be torn apart? Should he face a hefty penalty and deportation? But not only is this bill overly punitive, it is also unconstitutional, since it violates the Supremacy Clause, which gives the federal government inherent sovereign power to control and conduct foreign relations. And the Supreme Court has ruled in Arizona v. United States that immigration law is a province of the federal government, and I quote, "States may not enter in any respect an area the federal government has reserved for itself." We urge you to stand for the dignity of the human person by voting against Senate Bill 1372. Thank you, and if you have any questions for me, I'll be glad to take them.
On the constitutional issue that you raised,
Yeah.
the Arizona case, isn't it true that the U.S. Supreme Court actually found certain provisions of that bill to be constitutional?
Yes, it found certain provisions, but they are not the ones that would apply to this bill. Actually,
I think the provisions in that bill were different than the provisions in this bill, but essentially what the Supreme Court said is that states cannot enact new immigration laws, but they can put in place mechanisms that help support what is federal immigration law right now.
Well, but actually, one of the sections that the Arizona case struck directly is the one that Senator Schroer was referencing previously, which is law enforcement officers having to act upon probable cause. And I do think that that the Arizona case actually goes against this bill. It would not act in support of it.
Well, the U.S. Supreme Court held that the provision in the Arizona law that mandated that police officers check IDs for everyone they pull over to confirm their immigration status, the Supreme Court specifically held that was constitutional. In that case, they specifically held that provision was constitutional and that you had to make a referral to ICE.
Well, I would be glad to submit like the highlighted portions of the bill of the case that I think applied to this bill to the committee later on.
Okay. You do agree that there can be overlapping jurisdiction, though, between federal and state?
Yes, but there are many nuances in that regard.
Okay. For example, we have the ability to enforce laws that are on the books for the feds where the state has a separate enforcement mechanism. So, for example, the federal government can prosecute what they call federal felon in possession, which are firearms offenses for somebody who's committed a felony and they're in possession of a firearm. That is a federal crime. It's the most prosecuted federal crime under the U.S. Code. We have a state analog that's known as unlawful possession of a firearm. So the feds can prosecute essentially the exact same crime as the state can. And the way that I'm reading Senator Eigel's bill is he's actually citing, in his offense of improper entry, he's citing the United States Code, which makes it illegal to be in the country without going through the proper channels. And so it seems to me all his bill is doing is allowing the state to help enforce federal law.
I would disagree, but I can understand why you're saying that.
Okay. Any further questions for the witness? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in support. Witnesses in support of Senate Bill 1372. Seeing none, further witnesses in opposition. Witnesses in opposition to Senate Bill 1372.
Good afternoon. My name is Gabrielle Eisner, and I'm a co-director of the Interfaith Committee on Latin America, an organization that has worked alongside immigrants and their families here in Missouri for over 40 years. And on behalf of the Interfaith Committee on Latin America and the individuals and congregations we represent, I urge this committee to oppose SB 1372. As we're seeing in Texas right now, that there is Supreme Court precedent on this, and so I think in passing this bill, we would be opening up Missouri to a painful and expensive legal battle. And as a Missourian myself, I don't want my hard-earned taxpayer dollars to be going toward a legal battle with the federal government. I'd also like to add that if this bill were to take effect, the already pervasive issue of racial profiling would increase. SB 1372 requires law enforcement officers to arrest people when probable cause exists that they are here without authorization. And I'm curious what would constitute as probable cause. Is it a person's race? Is it their ethnicity? By targeting certain groups of people, this bill amounts to a racially divisive and deeply hostile social policy. Law enforcement officers across the country have said that they cannot adequately determine whether an individual is lawfully present because immigration status is nothing more than a legal construct that is not readily apparent when viewing a person. I also want to address the provision of this bill that would bar all undocumented students from post-secondary institutions. I think by now it is common knowledge that an educated and skilled workforce benefits the entire state. By 2028, an estimated 65% of Missouri's jobs will require some level of post-secondary education. But right now, less than half of the state's working age population currently has any post-secondary credential. Why then would we deny undocumented students, many of whom have attended primary and secondary school in Missouri, the opportunity to receive a higher education? Thank you.
Thank you for your testimony. Questions for the witness? Seeing none, thank you for your testimony.
you.
Further witnesses in opposition to Senate Bill 1372.
Okay. Thank you very much to the committee for listening to me today. My name is Itzel Vargas, and I am with Advocates for Immigrant Rights and Reconciliation, a nonprofit, interfaith nonprofit in Kansas City, and we're also part of the Missouri Immigration Policy Coalition. I'm here to testify against SB 1372. I think this bill would set the state 10 steps back, limit education to some immigrant students just because at the moment may not have illegal status, but may be on their way to getting one, does not make this state any better. And it's well known in the Kansas City area that students from Missouri who have graduated at Missouri High School and who may be currently affected by the tuition language in the higher education budget bill, they can go to Kansas, and many of them do, where many universities offer a metro rate or a Midwest rate. It is known that Kansas State University is actively recruiting undocumented students and giving hefty private scholarships to those students. Those students do not come back to Missouri. They stay out of state, and that's, as it's been mentioned before, exacerbating the workforce crisis that is happening in Missouri. The students are people that can stay here, that can work here if given the opportunity. And as Gabby mentioned, an uneducated society is no benefit to anybody. So I urge this committee to vote against it. Thank you.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in opposition to Senate Bill 1372.
Good afternoon, members of Missouri Senate. My name is Yasmin Bruno Valdez, and I am currently residing in Kansas City, Missouri. And I stand in opposition of Senate Bill 1372. I am an undocumented and unafraid. Education is a fundamental human right. Regardless of immigration status, everyone deserves the opportunity to learn, grow, and thrive. Despite facing rejection from every booth at my high school's college fair, I maintained a stellar GPA, high testing scores, and an unwavering commitment to my education. Nearly 4 years ago, despite numerous obstacles, I was awarded a full ride scholarship, and I recently graduated from Rutgers University, where I studied political science and nonprofit management to further support my community in Kansas City. Our federal government has failed to establish a pathway to citizenship for immigrants that strive to contribute to this economy and community. We should not punish immigrants for wanting to pursue higher education and develop careers that enhance Missouri. The reality is that if you pass this bill, you are denying the dignity and opportunity of thousands of undocumented students that live and love Missouri communities. Blocking funding opportunities for low-income undocumented individuals and penalizing their commitment to their education deprives our schools and communities of talents, skills, and contributions that are significant to Missouri. It's time for policymakers to acknowledge the immense value that immigrants bring to our society and economy. I ask that you take into consideration that education should not be a luxury only awarded to those fortunate enough to live under favorable circumstances. Regardless of immigration status or income level, the right to education is undeniable and should be accessible to all. So please vote against Senate Bill 1372.
Perfect timing, by the way, too. Thank you for your testimony. Questions for the witness? Seeing none? Thank you. Further witnesses in support of further witnesses in opposition to Senate Bill 1372.
Good afternoon, members of the committee. Chairman, thank you for the opportunity to testify. My name is Karina Rango, and I serve as the Director of Advocacy from the Scholarship Foundation of St. Louis, a nonprofit located in St. Louis, Missouri. And our work at the Scholarship Foundation focuses on students who are low income and or first in their family to attend college. I'm here today to express the importance of higher education for all Missouri high school graduates, and specifically those students who are undocumented. Do not unjustly penalize our state's young people for an immigration system that has been broken at the federal level for decades. Senate Bill 1372 will move Missouri backwards. If Missouri wants to consider itself competitive in degree attainment, the state should work towards making higher education accessible. The Missouri Department of Higher Education and Workforce Development set a goal of 60% of Missourians between the ages of 25 and 64 to have a post-secondary degree or credential by 2030. The original goal was set for by 2025. As it stands, just under 50% of Missourians over the age of 25 have earned a degree or credential. Senate Bill 1372 would prohibit higher education for undocumented students and further undermine state and local investments in Missouri's K-12 education. Since 1982, the U.S. Supreme Court has recognized the right to kindergarten through high school education for all students, regardless of immigration status. Restricting undocumented students to higher education harms all of us. It targets and punishes undocumented students, wastes the taxpayers' investment on K-12 education, and undermines state education goals. Missouri needs to move toward greater opportunity for all its residents, and the denial of an education will do the exact opposite.
Thank you for your testimony. Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in opposition to Senate Bill 1372. Seeing none, any witnesses for informational purposes only on Senate Bill 1372? Seeing none, this will conclude the hearing on Senate Bill 1372.
Mr. Chairman, I beg your leave. There's another committee that is underway, and I have a bill to present there. Just as soon as I finish here, I may just head out. If that's okay. Thank you very much. Here to present, thank you for allowing me to present Senate Bill 951. I'm Mike Moon, and I represent the 29th Senatorial District. Welcome back. This particular bill will allow for the death penalty for statutory rape and sex offenses in the first degree. And I have to ask the question, first of all, what is one of the principal purposes of government? And that is to punish evil. And what's more evil than the taking of an innocent child, or taking the innocence of a child during the act of a rape? Citizens or children in large part are defenseless. And an act such as rape can kill the child emotionally, and so I believe a just consequence after a reasonable opportunity for defense is death. A cursory search allowed me to find at least 4 situations that happened in Missouri, where one was a 23-year-old abused a 2-year-old. This perpetrator was charged and sentenced, and in that sentence there was a $5,000 fine and a 30-year sentence. Another one where a 36-year-old abused a 9-year-old and an 11-month-old, receiving an 80-year sentence. Another where a 28-year-old abused a 12-year-old, and they're awaiting trial in that particular situation. One instance is really sad, where the father abused his 8-year-old daughter and received a 295-year sentence. And when perpetrators are found guilty of such a heinous act, it just doesn't make sense to keep them incarcerated where they can live 3 meals a day, exercise yards, and then potentially get out early, only to perhaps commit another crime. And so I believe it's just and fitting, as I mentioned earlier, when you're taking the innocence of a child, killing them emotionally, it just makes sense to take the life of that particular perpetrator. Be happy to answer questions if you have any.
Just one quick question, because I know it's going to come up as soon as you get done testifying. There are going to be opponents who are going to stand up and they're going to say there's a U.S. Supreme Court case called, I think it's Kennedy versus Louisiana, where the U.S. Supreme Court had previously struck down a similar measure from Louisiana as unconstitutional. And I just wanted to give you an opportunity to speak on that, because I'm sure that issue is going to get brought up.
Well, we often talk about settled law. And if law were actually settled and not to ever change, we would have a lot of things today that we wouldn't have the possibility to take part in. I think many of the members on the committee, since most of, except for one is an attorney, know of some of those cases. So I think this is something that we need to start the conversation about, and those things need to be challenged, because as you alluded to, some of the cases that have been decided by the court have been overturned. And so I believe that if we just say, well, Supreme Court, they're going to settle this, well, actually it's not settled. And I think that we need to challenge some of those decisions that are made. And I believe if we do that, other states might follow along. But I believe that that proper sentencing and consequences should be afforded those who commit heinous crimes such as this one.
I'm correct, right, that Florida did something very similar to this, is that right?
Mm-hmm.
Recently, like in 2023?
Yes, sir.
Okay, and that was signed into law by the governor in that
Yes.
state. Yeah. Senator May.
So I'm just clarifying, because I don't know, I have to look up this statute. Child in here is defined as what? Under 18 or?
It's in the first degree, so it would be, is it?
I think it might be 14.
Under 14, I think it's first degree.
So it's 14
or younger.
Or younger. Is that in RISMO 566-250? Where they define child? I'm trying to see. I didn't see it. That's why I'm asking. So it doesn't say it in there.
It's 12 or younger.
Okay. So thank you. So my question is this. So Senator, you believe that you don't believe in abortion with exceptions to rape or incest. So if you don't believe in it, then a 12-year-old who gets pregnant, you believe that she should bring that child in the world. Am I correct?
What crime did that child, that developing human child, commit to deserve death?
That's not my question. My question
Well,
is
you
asking
you mentioned
No,
that I was
asked
against
you, do
I was
you believe
against
that a 12-year-old
abortion.
who was raped, who's gotten pregnant, do you believe that she should have that child?
That decision is often left up to the parents and with the child. And,
I don't know.
But my answer to that stands. What did that developing human child do to deserve death?
That's not the question. The question is this.
That is the answer, though.
No.
That is my answer.
That's your answer. You
That
said
is my answer.
So you saying that the child in the womb, the 12-year-old child that got pregnant with a child, you don't give them the option according to the law that we passed for rape and incest, because that's what I know that you passed. So, but you believe in killing the father to that child.
If an attacker commits a heinous crime such as the one that I mentioned in this presentation, I believe that if they're charged and convicted, absolutely.
Okay, so you believe that we should kill the father and the baby safe.
You don't kill a child for the offenses of the father. That's certainly true. I think you would agree with that. At least I hope you would.
Well, I don't know.
But
I don't stand in judgment.
But a person,
I don't believe in the death penalty.
a person who impregnates another is not really necessarily a father just because they impregnated someone. A father is someone who loves the wife and nurtures the children and provides for them. And they would not perpetrate a crime such as the one that I mentioned on them either. But if that happens, yes, I believe they should die.
Okay, I'm just saying, believing in life.
Yes, ma'am. And you are a follower of the Scripture, and I think you'll find where there are scriptural references to particular crimes that deserve death. So you have to count it both ways there.
But God was administering the death.
God was?
God was, not man.
I don't think he picked up the stones.
I mean, well, those individuals.
But God
I
did
remember
write the
that
law.
one incident where they tried to stone one woman who they said they caught in the act.
And God
Mary
did write
Magdalene, and he said, "He who without sin cast the first stone."
Yeah, I think there's a lot more to that story, but God did write the laws, and so I think we have to follow his law in all aspects too. Thank you for the
Thou
question.
shalt not kill.
That's murder.
Mm.
That's murder. It's murder. Right, I'm just answering.
Any further questions for the senator? Seeing none.
Thank you for allowing me the opportunity. I'm going to head up.
Thank you. First witness, actually, let's do a show of hands. How many witnesses do we have here in support? Okay, how many witnesses in opposition? Okay, we're going to do the same rules as the last bill. 5 minutes for the principal witness on each side, for and against, and then 2 minutes for every subsequent witness. First witness in support of Senate Bill 951.
Good afternoon. My name is Timothy Faber, and thank you for allowing me the privilege to speak to you today in support of Senate Bill 951. It is a well-established fact that there are lifelong repercussions of rape and child trafficking experienced by those who are victims of such atrocities. Lack of self-worth, extreme difficulty managing emotions, continuous underlying stress, and struggling to have healthy relationships are just a few of those problems, and they struggle with those their entire life. In some cases, the result may include also sexually transmitted diseases and even in some cases, unwanted pregnancies. And certainly both of those instances have lifelong consequences. Oftentimes, the victims of such crimes wrestle with the terror of their violation every single day for the rest of their life. Even decades afterwards, they may not experience a single day where they are free from the violations that they were forced to endure. And even if they do manage to gain a small measure of freedom, that trauma can be triggered by a variety of otherwise innocent behaviors, such as a husband simply coming up behind his wife to give her a hug. The perpetrator of such crimes is deserving of life. What's fair for the goose is fair for the gander. It's also a well-established fact that those who commit sexual crimes seldom, if ever, change their ways. Once a sexual offender, always a sexual offender. This is why, even now, a person convicted of a sexual offense, sometimes even much less than the ones addressed in this legislation, must continue to register as such, and they are not allowed to live within a certain distance of a school, and they're generally not allowed to be in places alone with children. But even that, to consider a lady who is a victim of rape, trying to put it behind her, trying to live a normal life, in spite of the struggles that she faces within her own marriage, then a sex offender moves into her neighborhood, and suddenly the home she fought so hard to attain in a neighborhood that was once safe is now, to her, a place of danger every time she goes out the door. Through no fault of her own, she is once again traumatized. Why should the violator be free? Why should the violator, even after a prison term, be allowed to go about their business when they have imposed life-changing, life-altering, and sometimes life-destroying circumstances on someone else? As for those who are trafficking children, well, it should be evident to all that they need to be dealt with. There are those who are trying to use the term minor attracted person. They're perverts. That's what they are. Manipulating, abusing, threatening, playing on the naivety of young minds and hearts. Have you seen the movie Sound of Freedom? If not, I challenge you to watch it. It's available on a variety of platforms and streaming services. If we don't do what is necessary to protect the children, the minors, the women, the ladies in our culture, who will? Thank you.
Thank you for your testimony. Any questions for the witness? Seeing none, thank you for your testimony. First witness in opposition to Senate Bill 951.
Hello, good afternoon. Chairman and committee members, thank you for having me this afternoon to testify in opposition to Senate Bill 951. My name is Elise Max. I'm the co-director at Missourians to Abolish the Death Penalty. We are against expanding the death penalty for non-homicide offenses in our state. As mentioned, we know that the U.S. Supreme Court case law expanding application of the death penalty to non-murder cases is unconstitutional under Kennedy versus Louisiana. And those decisions are grounded in the cruel and unusual punishment clause of the Eighth Amendment. If the goal is to overturn established U.S. Supreme Court precedent, it's far from a guarantee. And the amount of resources the state of Missouri would have to spend, as well as the trauma to child victims during the process, cannot be understated. To have a test case to try and change this precedent, there would have to be a trial and a death sentence. That means expanding all the attendant costs that go along with the death penalty prosecution, and would include a trial where a child victim would have to testify. In Missouri, the law protects children. First-degree statutory rape and sexual trafficking of a child is already punishable by life in prison under Missouri statute, and persistent offenders can receive life without the possibility of parole. Unlike imposing a life sentence, seeking and imposing the death penalty in such cases would require a child victim to endure the trauma of a potentially decades-long trial, appeals process, and with no increase in public safety compared to the status quo. In addition, experts warn that such a law could worsen the problem of underreporting child abuse. Missouri will be even more of an extreme outlier in capital punishment. Adding statutory rape and trafficking as death-eligible crimes are a slippery slope of expanding the death penalty to non-murder crimes that would bring the constitutionality of Missouri's death penalty into doubt. Not including prosecution expenditures, death penalty cases cost 3 to 4 times the amount to prosecute. The costs multiply as death penalty cases make its way through the required constitutional and statutory appeals processes. Lastly, there is no evidence that the death penalty deters crime. The state of Missouri's resources are better spent in trying to protect children from abuse in the first place and making sure those that are abused have access to mental health treatment and continued therapy immediately after the offense. In summary, a sentence of life without parole is a harsh and severe punishment, including for a person convicted of child sexual abuse. Instead of spending millions of dollars to possibly change longstanding precedent, Missouri resources should be spent to protect children from abuse in the first place and ensure survivors have access to mental health treatment and proper support following the offense. Please vote no on Senate Bill 951.
Any questions for the witness? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in support of Senate Bill 951.
Lisa Panett, Armor Vine. We want to protect our kids. So this is the measure to protect our kids. I think that they would be thinking twice about abusing our children if they knew there wasn't going to be a second chance. They touch one of our little ones, they're done. And I think as moms, that's what we care about. We protect our children. You come after our children, we're going to protect them at all costs. And this is saying the state of Missouri is going to protect them at all costs. That's all.
Thank you for your testimony, Lisa. Questions for the witness? Seeing none. Further witnesses in opposition to Senate Bill 951.
Mary Fox, Director, Missouri State Public Defender. Missouri State Public Defender is the organization that provides a defense for the majority of death penalty cases in the state of Missouri. I appreciate that you brought to everyone's attention that this legislation as written would be unconstitutional under current Supreme Court case law. And that is based upon the Eighth Amendment, that it is cruel and unusual punishment. I think the more important question is, does it accomplish anything? And the research that has been done is that the death penalty is no deterrent to a crime. Dr. James Gilsonen of St. Louis University and Dr. Timothy Decker from Arizona State University both did extensive research on the question, does the death penalty serve as a deterrent? I would think a deterrent to creating a deterrence to crime is an important part of the legislature in a state. And the research is clear that killing people does not cause other people to think about whether or not they should commit a crime. It has no impact whatsoever. The other thing that I think is important is that you had some questions about the age. This is under the age of 14, but a 15-year-old can be charged with this crime. A 16-year-old can be charged with this crime. And obviously anyone under the age of 18 cannot be executed under the current law from the Supreme Court. But we could have an 18-year-old who is dating a 14-year-old. This is 14 is the law on statutory rape in the first degree. So I would say I am opposed to this bill, and if it is passed, it will face the scrutiny of a declaratory judgment in the state of Missouri before it gets to any prosecution, and I don't think there are any prosecutors in Missouri who would proceed under this bill knowing that it does not meet the requirements of the Constitution. Thank you.
Any questions for the director? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in support of Senate Bill 951. Seeing none, further witnesses in opposition to Senate Bill 951.
Hello, my name is May Hall. I'm a resident of Columbia. Initially, the plan was to come up here and say what's been said before. The death penalty does not act as an effective deterrent. It's unconstitutional under current precedent. But honestly, I think that there needs to be a perspective shift as well in this testimony. I come forward not only as a citizen of Missouri, but as a victim of childhood sexual abuse. And I can say with complete certainty that this bill would do more harm than good. Being young, it was mentioned earlier, when you're young and particularly a relative is engaging in this behavior, if you are aware of the fact that reporting them could lead to their death, you are not going to do so, speaking frankly. Because it will weigh on the rest of your mind, or it'll weigh on your mind for the rest of your life that you killed that person. And when you're young, it's impossible to truly know how to handle that emotion, and so you stay quiet. I personally never reported my assault because, I mean, even under current law, because I was scared of getting someone in trouble. And when you're a kid, that's just how your mind works. That's not to say that this was in any way an acceptable thing. I still deal with the mental and emotional scars. But that being said, I don't wish my abuser death. I wish them to be sequestered away and unable to harm more people, for sure. But I don't think it's the state's place to kill people in general. And I don't think it's the state's place to make it more difficult for child victims to come forward. I disagree with the fundamental premise of this bill. I don't think it's the purpose of the state to punish evil. I think it's the purpose of the state to take care of its people. And so the way to do that isn't to threaten to punish or threaten to kill abusers. It's to protect and support victims, whether it be before they are attacked or after. Having had this experience and not being able to report it, I did not receive that report or that support afterwards. And the effects have been dramatic. And so I think when we're talking about things like protecting the children, the real answer is to address the systemic problem of mental health and trauma care and even just physical health care afterwards. And not to go the most bloodthirsty route possible and kill someone and then leave that child to just deal with the emotional fallout. I'm happy to take any questions.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in opposition to Senate Bill 951.
Thank you, Mr. Almost lost a pocket there on the armrest. Thank you, Mr. Chairman, members of the committee. My name is Jeremy LaFavor, appearing today on behalf of Empower Missouri for all the reasons that we've heard today, certainly the unconstitutional arguments, but also the argument that it makes it more difficult and challenging for many child victims to come forward and to get these cases adjudicated and get that punisher or that abuser away from the victim and away from society. So for those reasons, we'd stand in opposition.
Any questions for Jeremy? Seeing none, thank you for your testimony. Further
Thank you, sir.
witnesses in opposition to Senate Bill 951.
Mr. Chairman, members of the committee, Brian Bernskater here on behalf of the Missouri Association of Criminal Defense Lawyers. I want to ditto Mary Fox's comments and go on record in opposition.
Questions for Brian? Seeing none, thank you for your testimony. Further witnesses in opposition to Senate Bill 951. Seeing none, any witnesses for informational purposes only? Seeing none, this will conclude the hearing on Senate Bill 951. No further business coming before the committee. I would now make a motion that we adjourn. It's been moved and seconded. We are adjourned.